If you've been involved in a motor vehicle accident, the police are likely going to be investigating whether or not alcohol was a contributing factor to the collision. An accident is often a way that many impaired driving investigations take place, and often a way that they begin. There are two important facts that a police officer is going to have to determine in circumstances of an accident. The first is when the accident occurred. The second is whether you were driving at the time of the collision. Both of these factors are because of provisions in the criminal code. The criminal code requires a police officer who's demanding a breath sample, a roadside sobriety test, a drug recognition evaluation, or a blood sample to have reasonable grounds to believe that you were the one driving the vehicle, or to reasonably suspect it, depending on what type of demand they're making. And we'll address those demands in later videos in this series. The criminal code also requires the police officer to know when the accident occurred, because certain demands require the officer to make them within a certain amount of time from when the accident happened, and if your breath or blood samples are taken more than 2 hours after you ceased to operate a motor vehicle, certain procedures in the criminal code apply to relate the readings that were taken from you back to the time of driving. If they were taken within the 2-hour window, then the police officers and the court and the Crown are all permitted to assume that your reading matches what it was at the time that you were operating the vehicle. For these reasons, police have to determine these two key pieces of information. Just because you admitted driving doesn't necessarily mean that statement is going to be admissible as a fact at trial. If you admit driving, the police have to prove that you made the statement voluntarily. Additionally, there are provisions of the criminal code that prohibit the use of a statement where a person admits to being the driver of a vehicle as proof of a fact at trial, and limit the use only to giving the officer grounds to believe that you were the one driving the vehicle in order to make certain demands of you for breath, blood, or physical samples. This is why the statements that you make to a police officer at an accident scene must be carefully considered in an impaired driving investigation for their limited purpose in court and for the way that they can be used as evidence against you.